employment-based non-immigrant visas. Breaking this down, the employment-based part of it, in general, there must be a U.S. employer that will sponsor you, the foreign national, for the visa. That's either through a current job offer, a future job offer. In some visas, you may be able to have a controlling interest in the petitioning entity, so you can essentially be self-employed under that. That's generally the O1 visa where we see that come into play. It's also an option as of this year for the H-1B visa, but that's less applicable to this particular webinar, as we'll be dealing with cap-exempt entities. The non-immigrant part of that means it's a temporary status in the United States. It can be contrasted with lawful permanent residence, which is the green card. That's the immigrant visa process. The United States immigration system is antiquated and very much out of date, needs a complete overhaul, as I'm sure all of you are aware. But on the employment-based side, as of right now, what we're dealing with is a very siloed framework. So each category has its own eligibility criteria, and some have particular employer-employee relationships, and those requirements have to be met. There is no general work visa in the United States. There's no one-size-fits-all within U.S. immigration. You have to look at the specific facts of your case and determine which of the applicable visa categories apply to you, and the employment situation you're dealing with. So the H-1B lottery this year, that's fiscal year 2026. The lottery occurred their selection process occurred at the end of March earlier this year. A few weeks ago, USCIS announced that there will be no second round of selections this year. In years past, they have done another round of selections for a few hundred or 1,000 or so additional applicants that would be able to apply this year, based on approval rates and the number of petitions they've picked. There have already been a sufficient number of petitions filed to meet the quota of 85,000 visas for this year. Again, this year, as in many years past, most registrants were not selected. The total number of applications this year hasn't been released yet, but it's generally expected to be somewhere between 300,000 and 400,000. So generally, you had a 1 in 4 or 1 in 5 chance of being selected. There may still be options for you, even if you weren't selected. We're going to start by discussing the cap-exempt H-1Bs. These are institutions that do not have to go through the lottery process. Essentially, they can apply for an H-1B at any time of the year. There is no cap on the number of H-1Bs they can apply for, either as an institution or collectively. The types of institutions that qualify as cap-exempt include accredited nonprofit universities. So this is almost all of the major universities you've heard of in your day-to-day life. It also includes nonprofit organizations that are affiliated with those universities, and includes nonprofit and government research organizations. This is a kind of a limited pool of institutions that qualify as cap-exempt. There is no master list out there of cap-exempt entities that you can refer to kind of hunt for them. You just need to determine that on a kind of a case-by-case basis. In general, if it's a major university, it's going to qualify as cap-exempt. Some nonprofits will qualify if they have that relationship with the university. Either they have a working relationship where students from the university come to either train with them or perform internships there, and it's a major relationship that really shows a lot of cross-pollination between those two entities. Additionally, there's the nonprofit and government research organizations. Again, these are a select few that are have whose major function is research. Either it's a government institution or a nonprofit who conducts research on a large level. So, like I said, there's no master list out there of these types of entities. You just when these entities are hiring individuals, if they require sponsorship for employment authorization, they'll know whether or not they're cap exempt, and can hire you at any time of the year. Cap exempt H-1Bs are, other than not having to go through the lottery process, are identical to other H-1Bs that requires a specialty occupation, which means a bachelor's degree or its equivalent as a minimum to enter into the profession. And the institutions, they're valid for initially 3 years and can be renewed for an additional 3 years for a maximum of 6 years total in H-1B status. Other alternatives to the H-1B, there are many. Not all will apply to each job. As I said before, it's a very siloed system. So depending on where you're from, the type of employer you work for, or your particular skills, there are different visa options that may be available to you. One, which I'm sure most of you are aware of, is a STEM OPT extension. A lot of individuals come to the United States as students. Upon graduation from a university, they're eligible for OPT employment. That's generally good for 12 months. If your degree is in a STEM field, then you may be eligible for a 24-month extension of that employment authorization, so up to 3 years of OPT. If you're not aware, if you have STEM OPT as an option for you, you can check your Form I-20 and look at the code for the degree or your major program, and then you can look that up online to see if whether or not that qualifies as a STEM field. If that's the case, then you may be eligible for a 2-year extension of your OPT, which will buy you more time to enter the H-1B lottery if you have an employer that registers for you. Another option that many people avail themselves of if they run out of chances in the H-1B lottery. For instance, if their STEM OPT has expired or is expiring before the next registration period, many individuals will go back to school. A new degree in a different field or at a higher level will allow you to, could possibly allow you to get CPT, which is curricular practical training, or OPT again upon graduation. The CPT occurs during school, so you're basically working for class credit. Certain programs allow for CPT. It's a school-by-school basis. They make the determination of whether or not curricular practical training is an option for their program. Some require that an individual be in the program for 6 months or an entire 1 semester or 2 semesters before being eligible for CPT. Some programs allow what's called day 1 CPT. So essentially you can work for credit from the start of the program. If you're considering this route as a way to stay in the U.S. and stay employed with your current employer through day 1 CPT, it's very important to ensure that the institution you're going to school, that you're using for going back to school and getting the CPT is an accredited, legitimate school. There are a lot of, if you Google day 1 CPT, you're going to get a lot of hits. So you need to do your research and be careful that you're choosing a legitimate program that has, accreditation, and works with, an international student office to, help you get everything you need to achieve the CPT, and work with your employer to make sure that everything's documented and processed correctly. You don't want an instance where, a school ends up to be, fraudulent, and then basically it in that case, it can really hinder your ability to get any future visas, including the H-1B that you're on. Other options that I'll cover in more detail as we go forward include the E3 and TN visas. Those are for Australian, the E3, and Mexican or Canadian citizens, the TN. I'll cover the L1 intercompany transfer visas. This can be used as a path towards a green card. The EB1C in particular for multinational managers or executives. And also discuss the O1 visa. This is the extraordinary ability visa. This, like the L1, is a path to a green card. This through the EB1A extraordinary ability category. And then I'll finish up with a brief talk on the E1 and E2 treaty trader and investor visas. Finally, at the bottom of this list, you'll see employment-based green cards. This is the PERM process where an employer can go through a test of the U.S. labor market to see if there are U.S. workers available and qualified for the position. This process takes 3.5 to 4 years. So it's a very long-term solution. So in general, employers won't do this if you're not already working for the company. It requires a very kind of a special relationship to have someone, have an employer invest that time and money into an employee if they're not going to be able to start for 3.5 or 4 years. But that said, it's not necessary that you be a current employee for them to start the green card process on your behalf. It can be done at any time. You don't have to be a current employee. You can be a current employee who has worked there for only a few months, has worked there for several years. The green card process can begin, can be started by the employer when they so desire. Moving on to the E3 and TN visas. The E3, as I mentioned, is for Australian citizens. It is limited to 10,000 per year, so there is a cap. It has never been reached. They've never even come close to that. So in essence, there's not, while there is a limit, we haven't run into it yet. It's very similar to the H-1B in that it requires a specialty occupation, which again is a position that requires at least a U.S. bachelor's degree in a specific field for entry into that occupation. It can be renewed indefinitely in 2-year increments. You can apply either through USCIS in the United States, or you can apply at a consulate abroad for the E3 visa. The drawback to the E3, despite being renewable indefinitely, isn't a clear path to a green card. It's less direct than there would be with the H-1B due to dual intent or non-immigrant intent issues with that visa. The same holds true for the TN for Canadian and Mexican citizens. It's not a direct path to a green card like the H-1B or L1 or O1R. There would be travel restrictions and certain other things that would apply. And kind of the process you'd have to go through for the green card would be different than it would be under an H-1B. The TN visa can be distinguished from both the H-1B and the E3. It doesn't follow the specialty occupation definition. It's limited to the list of professions that are in the USMCA, or the formerly NAFTA. The list of professions is limited, and each profession has its own education and or experience requirements that you must meet. Canadians can apply at the border, so they can just prepare the petition and when they plan to enter, either go to a pre-clearance at an airport or at a land border when they come into the U.S. They can also apply through USCIS and get the approval and then enter. That way, it tends to be re-adjudicated at the border regardless. if that's your first TN visa. Mexicans have to go through a U.S. consulate abroad, so the TN application must be filed with USCIS for the first one, and then it can be then upon approval, the Mexican citizen can make an appointment at a U.S. consulate to get the visa. They're initially valid for up to 3 years. Again, they can be renewed indefinitely, like the E3. The renewal period is dependent upon the contract you have with your employer, or the relationship you have with your employer that shows you've got work available for those 3 years upcoming. There was a very recent update on TN visas. USCIS made clear that engineers with a computer science degree, or those individuals with computer science degrees, do not strictly qualify as engineers for doing engineering work. It used to be the case that you could show computer science. People with a computer science degree were in fact engineers. Now USCIS has stated that no, that's not the case. So you're going to have to apply under the probably the computer systems analyst category or profession rather than under engineers. That said, we did just have a petition approved at the border for someone with a computer science degree in the engineering field. So we'll see how it's being applied going forward. The L1A visa. So this is intra-company transferees. This may be an option for you if you weren't selected in the H-1B, if your company is multinational. They may be able to transfer you abroad to work for a year and then bring you back in on the L1A visa. The basic requirements are that there's a relationship between a U.S. and a non-U.S. entity. So it must be a multinational corporation with an entity in the U.S. And an entity outside the U.S. You have to have one continuous year of employment at the non-U.S. entity. Thus, you'd have to, leave the U.S. for a year if you haven't already worked at the company abroad. And then at the end of that year, you can apply for the L1A visa and come back in under that visa. There's 2 categories under the L. There's the L1A, which is for managers and executives, and then the L1B, which is employees with specialized knowledge. And we'll get into more detail on both of those in a moment. So, as I said, there's a required corporate relationship. So there must be affiliated companies that are doing business in the U.S. and at least one other country. The exception to this is if you're coming to the U.S. to open a new office. In general, for most people that registered for an H-1B and weren't selected, this won't apply. There'll already be an office in the U.S. that had registered for you and was hoping to hire you. So the companies can be both owned by a third company, or there could be common ownership between the 2 companies. One company can wholly own the other, so there can be parent subsidiary relationships. Any of those qualify as a relationship under the L1. Additionally, the foreign national must have been employed by one of those qualifying entities abroad for at least one continuous year within the past 3 years, or the 3-year period prior to filing the petition. That employment must have been in a managerial, executive, or specialized knowledge position. So if your U.S. employer, if you weren't selected in the CAP and your U.S. employer is going to transfer you abroad in hopes of getting that L1A visa in a year, in order for you to qualify for that, you have to be working in a position that's considered executive, so C-suite type positions, managerial, which we'll get into more detail on the definition of that in a minute, or have specialized knowledge. at that non-US entity in order to re-enter in a similar type position in the US. So managers and executives, the L1A, this must be either managerial or executive. It can't be a mix of the two. You've got to pick one of those categories and show that you qualify under that. The executive, these are people with control or that control operations of an entire company or entire division of a larger company. They generally are at the top level of the hierarchy or the organizational chart. They report only to the board of directors or shareholders or the CEO of the company. So these are, the highest level officers of a company. Managers, there's three ways you can meet the definition of manager. So you either oversee and direct other professional employees. So you show that the employees that are subordinate to you have bachelor's degrees, or the positions require bachelor's degrees to hold them. So you're managing other professionals. Additionally, you can show that you manage or direct multiple levels of employees. So you're managing managers that in turn supervise other employees. So there's, if you look at an organizational chart, there's your position, and there'll be, two or more levels below you that also will qualify as a manager, even if those positions aren't professional. And finally, you can manage an essential function of the company. So if you're not a people manager, it's possible you could be a function manager based upon your directing of a division or a certain workflow within the company that requires you to either work with many managers, or you kind of indirectly oversee lots of projects, things like that. That could be a function manager. Operations managers we often see don't have direct reports, but are definitely qualify as managers because of their oversight of a significant and essential function of the company. The L1A is initially valid for 3 years. It can be renewed in 2-year increments for up to 7 years. So you can go 3, 2, 2. Just as a note, if you come under a new office, L1, that's initially valid for 1 year and then can be renewed 3 times under 2 years to get or for 2 years to get to the 7-year maximum. So there's additional renewals required in the new office category. The L-1B visa is for individuals with specialized knowledge. So specialized knowledge can be very hard to demonstrate. USCIS and consulates are very strict on this. They scrutinize this very heavily. So it can be difficult to show. But the main things you're looking for are that the knowledge is not commonly held within the industry or within the employer. So either you're working with proprietary functions or materials or knowledge at your current employer. So therefore it's not, can't be commonly held within the industry, or you have a very niche job within your current employer. That makes, which shows that, you've got, your knowledge is indeed unique. It has to be complex or sophisticated. So it can't just be, can't be solely unique. It must be a challenging field, a field that requires kind of that. It's not necessary that it be a professional position, but that's kind of inherent in this qualification, that it be complex or sophisticated, is that it is a more advanced field that you're in. And then finally, it must be difficult to impart this knowledge to others. So you have to show essentially that there's a reason your company needs to bring you to the United States rather than having someone who's already in the US fill this role. So it's either, there's lots of training that occurs to gain that specialized knowledge, or your particular skills, and you're bringing knowledge of foreign operations to the U.S. company that you have, that U.S. employees aren't going to have. So you have to meet all three of those to really show that it's specialized knowledge, which, as I said, makes it difficult. The L-1B is different from the L-1A in that while it is still initially valid for 3 years, it can only be renewed for a total of 5 years. So you get 1 2-year renewal. It is possible to switch from an L-1A or an L-1B to an L-1A, and then take advantage of that additional 2 years if you move up to a managerial position or executive position in the United States. So you can switch and get an additional 2 years. Moving on to the O-1A, this is the Extraordinary Ability Visa. There's 3 buckets really you have to fill to prove your eligibility for the O-1. First, you have to show that you have extraordinary ability in your field. There has to be a petitioner, either a sponsor or an employer, to file a petition on your behalf. As I mentioned in the beginning, it can be a company that you own, either in part or 100%. That separate entity can file a petition on your behalf as a beneficiary. So that's one advantage the O-1 has over many other visa types. And then finally, you have to show that you're going to continue to work in your field of expertise. So that means you have to demonstrate that there's concrete work lined up. So if you're opening your own company in the U.S. to come over on an O-1A, you're going to need to show a detailed business plan and letters of intent, of the type of work you're going to be doing, or events lined up that you're going to be working at to show, there is a reason for you to be here in the U.S. Under the visa. It's not generally a indeterminate field. You're not coming here to find work. You're coming here to do work that's already lined up. There are 2 categories under the O-1. There's the O-1A, which covers individuals with extraordinary ability in the sciences, education, business, or athletics. And then there's the O-1B, which is for the arts, motion picture, and television. I'm going to focus mostly on the O-1A in this presentation, in general, because the H-1B and those that weren't picked in the cap are generally working in sciences, education, business, or athletics. They're not. The H-1B isn't particularly suited for individuals in the arts. So I'm going to focus more on the O-1A requirements here. But certainly, if you have extraordinary ability in those fields or work in those fields, on any level within those motion picture or television fields, whether it's in front of the camera or behind it, if you can meet the extraordinary ability requirements, then obviously that could be an option for you from the H-1B. So the proof of extraordinary ability in your field. For the O-1A, science, education, business, and athletics, there are 8 categories of which you have to demonstrate 3 of to show extraordinary ability. Those categories are listed here. Each of these is a little bit broader than they may first appear with just this brief definition. So for awards, for instance, those can be, prizes you've won, either, a poster presentation, a significant scholarship that had multiple universities applying for it. So there's a broad pool of people that could have won it. Awards within the trade you're in, whether it's marketing or any field that presents awards to businesses or individuals for certain projects. Those would all qualify. The awards can be individual, so it can be a trophy with your name on it, or it could be a team award, as long as you can show that you had an important part of that project that won the award, and there's other corroborating evidence, then a team award can be used to show your extraordinary ability. The other categories include a critical or essential role for a distinguished company. So that's a kind of a 2-part one. You have to show that your role was important to the company, and then show that the company has a distinguished reputation. So it's either a larger company that is more well known, or is a smaller, more niche company that has has had achievements that you can point to. Third category is press about your work. So this press should be in major trade or media publications. So they shouldn't just be, small blogs or press releases that your company has put out about you. It should be independent and in larger circulation. Additionally, the press should mention you specifically and the work you've done. So it can't just be a kind of a passing note with your name on it. It needs to have at least some explanation to qualify for this. The fourth category is original contributions of major significance to the field. Again, this is a two-part criterion. There's both the original nature of the contributions, so they have to be, something unique that you've done that, is a new process or method for performing the work that you can point to with specifics to say, this was innovative. And then you need to show that it had major significance. So it went beyond just your employer. It was adopted by others in the field, or you received a patent for it. That's the kind of the quintessential original contribution. And then you need to show that patent was, is being used by other people, or, has provided a benefit to, either your employer or other employers, through licensing or something like that to show the impact. Fifth is high salary or remuneration. This is in relation to others in your field and in your geographic area. So you have to define your field well and where you'll be working to really be able to have that comparison of your salary or remuneration, which can include equity in a company, can be part of that, and then demonstrate that it's significantly higher than others in your field. Basically, you're one of the top 10% earners in your field and in the location you're working in. You can be an author of scholarly articles, or in business, you're not necessarily writing papers that are published in journals. So there's comparable evidence you can provide of authorship of white papers or other think pieces, or if you've presented at major conferences, something to show that you're kind of a thought leader within your field. You can have membership in outstanding associations. So this isn't just something you have an annual fee for. This is an organization that has requested that you join. Basically, there's an outstanding achievement requirement for the membership, and you've met that. And then finally, you can be a judge of others. So whether you've peer-reviewed papers or served as a mentor or worked in an incubator as kind of evaluating projects, all of those things can be considered judges of others. On the athletic side of it, if you're a coach, obviously you're judging the work of the players you're overseeing and deciding who makes the team and things like that. So you're like I said, each of these is a little bit broader than they first appear. So it requires a very careful analysis of your background to see whether or not you qualify. Finally, I'm going to talk about the E1 and E2 treaty visas. These are based upon, like the O1, this can kind of be an entrepreneurial type situation, where you're starting a company in the U.S. That can then apply on your behalf for the E1 or E2. It can be an already existing company that will qualify for this, but a lot of people use it as kind of an entrepreneurial way to start a company in the U.S. In contrast to the L1, it doesn't require that there be an entity outside the U.S. There's no specific employment requirement either within the U.S. or outside the U.S. It's more based upon the company and kind of the work that it's doing or the investment you've made in the company. So these visas are based upon treaties between the United States and specific other countries. So it's a country by country basis. There are I think around 110 countries that have either an E1 and or E2 visa treaty with the United States. You need to determine whether or not one of those treaties exists between you and your country of nationality. It's not a direct path to lawful permanent residence. The E1 is very strictly has very strict non-immigrant intent. You include a statement to depart the U.S. at the end of your status with your application. So if you want to pursue lawful permanent residence or a green card down the road, you need to consult with an attorney before you try to move from E1 or E2 to lawful permanent residence. It can be it's a bit of a tricky process that requires careful management. It requires an application through a U.S. consulate abroad. You may be able to change status in the United States from another non-immigrant visa category to E1 or E2. But even if you do that, the next time you travel abroad, you'll have to go through, you have to submit the application to a consulate. They'll review it, and then they'll call you in for a visa interview. It's a complete re-adjudication of the entire application for E1 or E2 status. So in general, most people start by filing with the U.S. consulate abroad. That way, you can come in and you'll be able to re-enter on that status rather than having approval through USCIS, then going abroad and finding out the consulate won't approve your status, and you're stuck with a company you've started and then no visa to come back in the U.S. So you generally go through the consulate abroad as a first plan of attack. The E1 requires that treaty company citizenship. So in order to qualify for either the E1 or the E2, the company that is the sponsoring entity is assigned a nationality. So basically the majority ownership of that company determines what nationality that company has. So if you're Irish and you own 100% of the company, then that company is Irish. If you're, from, say the UK and you own 51% of that company is, UK nationality. If the company has 10 owners and 4 of them are Irish and they combined own 60% of the company, that company is Irish. So it's the majority ownership that determines the nationality of the company. Then in order for you to qualify, you have to also have that nationality. So if you're Irish and the company is majority Norwegian, you can't get an E1 or an E2 visa through that company. So you have to have the same nationality. So that's the treaty company citizenship requirement. For the E1, this is the treaty trader visa. There has to be substantial trade between that country and the United States, within that company that's sponsoring you. So the amount of trade the company that's petitioning for the visa has with the U.S. must be substantial. This is generally in the tens or hundreds of thousands of dollars. So they do mean substantial in this category. And then the majority of the international trade of that company must be with the U.S. So if that company has $100,000 in international trade, at least $50,001 of those dollars must be with the U.S. It has to be, over half of their international trade occurs with U.S. companies or with U.S. consumers. For the E2, again, you have to have that same treaty company citizenship. And there must be a substantial investment that is at risk. Substantial in this case of the E2 is, kind of relative to the type of business and the startup costs that are involved with that business. As a rule of thumb, it's generally around $75,000 to $100,000 that has to be invested. And this investment has to be at risk. It's very important. The money has to be spent on the startup costs of the business. It can't just be sitting in a U.S. bank account waiting for you to get the visa and then come into the U.S. to spend that money. It has to already be spent. If you're buying an existing business, that costs $50,000 or $75,000, that money has to be in escrow. So basically, if the E2 visa is approved, that cost goes, to the seller, and it's there at risk. You have a chance to lose it if the business doesn't work out. That's what they're looking for. And with the E2, there's a limit on the type of role you can have. So you either have to be involved in the development and direction of a company, which if you own it, or are one of the owners of the company, that's generally a given. Or you can be an essential employee. So if you work for a company that is already registered with a consulate abroad as an E2 company, and they want to apply for an E2 visa for you, then they can. One of the things they can do is show that you're an essential employee. So you have, it's similar to the specialized knowledge of the L-1B. You've got, something they need in the U.S. That U.S. workers can't provide. So that's kind of the essential employee part of that. So one of the questions about a possible E3 visa for Ireland. This has been something that is near and dear to the heart of our founding partner, Fiona McEntee. And she's pushed for it for many years, and many other people have joined her in trying to push this forward to have an E3 type visa for Ireland, whether it be called an E4 or whatever they name it. It would be a similar type visa that's specifically set aside for those with Irish nationality. That hasn't gone anywhere yet, and it doesn't look like it's going to during this administration. I can't see that being pushed ahead. So I would probably say it's at least another 3 or 4 years away from a significant push for that being a reality. Unfortunately, we'd all like to see it. I think it makes sense given the relationship between our two countries, but it's still out there. It's still on everyone's kind of screens, but it's been backburnered for the foreseeable future. And then, as you can see in the chat, Liz, our fantastic marketing director, has provided many additional resources for you to learn about the O1 visa, additional information on the E3 and the TN as well, that are related to the topics I discussed. If you have any questions about any U.S. immigration issues, whether it be something I discussed today on the non-immigrant employment-based front, or it's an immigrant visa question, or family-based asylum or naturalization, we handle all of those cases. So if you have any questions, please feel free to reach out to us.